Good morning. My name is Jim Soberet, and let me add good afternoon to our friends in Europe and Israel who are joining us today. Today's program will be one in which we focus on some important developments that occurred in 2014 that will have lasting effects into 2015, and also some additional significant developments we see coming down the road in 2015. As the president of Brinks, Gilson & Leone, I want to assure you that our highest priority is to help our clients achieve their legal and business objectives. As a firm that concentrates solely on intellectual property, our goal is to help clients with comprehensive IP strategies tailored to their individual needs, which includes identifying IP assets, procuring protection, managing portfolios, and defending and enforcing IP assets. We have over 140 attorneys and patent agents that focus their work full-time on intellectual property, which gives us one of the deepest rosters of IP experts in all aspects of IP law and in every field of technology and science. We have 7 offices nationwide. Our headquarters is here in Chicago. We also have offices in Washington, D.C., Research Triangle Park, Detroit, Ann Arbor, Michigan, Indianapolis, and Salt Lake City. We are pleased that a number of independent publications that evaluate and rank law firms continue to give us high marks in the intellectual property field. I'm very excited today to introduce you to 3 of my colleagues who are standouts in various aspects of the IP field. Kelly Burris, who is the managing partner of our Detroit office and an expert in USPTO procedures, will be one of our speakers. Scott Slavic, who's one of our trademark experts, and Mircea Tepescu, who's one of our star litigators, will be addressing several topics today. Mircea will be our first speaker. He's going to talk about some hot topics at the ITC and what to expect in 2015. Kelly will follow. She's going to talk about effective use of some USPTO pilot programs and how they can be used for more efficient patent prosecution. Then Scott Slavic will talk about some important decisions from the Supreme Court last year affecting both trademark and copyright law and some continuing effects that they'll have this year and beyond. So, our first speaker is Mircea Tepescu. Mircea, welcome.
Thank you, Jim. Today I'll be discussing 2 recent developments at the ITC and what to expect as a result in 2015. Although the number of IP disputes filed at the International Trade Commission has declined over the last few years, the ITC continues to be a popular forum for intellectual property owners who are drawn to it by its speed and its unique remedies. 2 cases on appeal to the Federal Circuit have drawn considerable interest because of their impact on the ITC's remedy remedies that are available to petitioners. The first of these cases is ClearCorrect versus ITC and Align. It concerns the ITC's authority to block electronic data transmissions from abroad, including transmissions over the internet. The second case is Suprema versus ITC. This case is a controversial decision that limits the ITC's authority in cases involving induced patent infringement. But before discussing these 2 cases in more detail, I'd like to touch briefly on the types of injunctive relief available at the ITC. The ITC is an independent federal agency that handles IP disputes involving imported goods under Section 337 of the Tariff Act of 1930. Section 337 provides that unfair methods of competition and unfair acts in the importation of goods into the United States are unlawful. It also covers their sale for importation or sale within the United States after importation. Now, historically, most Section 337 investigations have involved allegations of patent infringement, but Section 337 also provides relief from other forms of unfair competition, including trademark infringement, copyright infringement, theft of trade secrets, passing off, false advertising, and others. Upon finding a violation of Section 337, the ITC may grant different types of injunctive relief. For example, the ITC may grant exclusion orders to prohibit the importation of infringing articles into the U.S. A limited exclusion order excludes infringing articles imported by specific parties found to infringe by the ITC. A general exclusion order, on the other hand, excludes all infringing articles from entering the U.S., regardless of their source. Now, the ITC may also grant cease and desist orders to prohibit conduct related to the importation of infringing products into the U.S., such as the sale of previously imported infringing goods. Similarly, consent orders prohibiting the importation of infringing goods may be issued to settle an investigation based upon agreements entered into by the respondent and the ITC. Significantly, the Supreme Court's decision in the eBay case, which sets out a test that governs injunctive relief in district court, does not apply at the ITC. So with that in mind, I'd like to turn to the Clear Correct case. Both Align Technology and Clear Correct manufactured custom dental aligners for straightening teeth using 3D digital models called digital data sets, which represented incremental teeth positions. The digital data sets were used to manufacture a series of successive aligners, which are worn by a patient in different stages of treatment to incrementally move the teeth. Now, in particular, Clear Correct had operations both in the U.S. and in Pakistan. Clear Correct USA collected patient data in the U.S. and sent the patient data to Pakistan. The foreign affiliate used the patient data to generate the digital data sets in Pakistan, and it then electronically transmitted the digital data sets to Clear Correct USA from Pakistan by uploading them to a server located in the U.S. Clear Correct USA then used these digital data sets to manufacture and sell aligners in the U.S. As a result, Align sued Clear Correct in the ITC for infringement of 7 patents directed to systems and methods using digital data sets for making dental aligners. The ITC found a violation of Section 337 based on 5 of these asserted patents. And it did so based on its authority to remedy unfair acts of infringement that involve the importation of articles as described in Section 337. In particular, the ITC Commission affirmed the administrative law judge's finding that electronic transmission of digital data sets into the U.S. constitutes an importation of articles within the meaning of Section 337. Now, Section 337 does not explicitly define the meaning of the term articles. Instead, the Commission looked to the intended meaning of the term articles and found that it encompasses such items as are bought and sold in commerce and that are imported into the United States, regardless of the mode of importation. In essence, the Commission found that digital goods are articles of commerce. That leads us to 2 conclusions. One, electronic transmission, such as uploading digital data to a server over the internet, is an act of importation. And second, digital data itself is an article within the meaning of Section 337. As a result of its finding of infringement, the Commission issued cease and desist orders based on the violation of Section 337, but it stayed those orders pending the appeal of the case. The Commission recognized that the definition of articles is a difficult question because the term is not defined by the statute and because this is a question of first impression. Also importantly, the opinion of the Commission was not unanimous. Commissioner Johansson issued a dissenting opinion in which he explained why he thought articles should not include digital data sets at issue in this case. He noted that exclusion orders cannot apply to electronically transmitted goods. In other words, issuing an exclusion order against electronic data is incompatible with Section 337's remedial scheme because electronic data transmissions cannot be held or presented to customs and cannot be granted or refused entry by customs. Now, the respondents in the case, Clear Correct, appealed to the Federal Circuit. And in its appeal, Clear Correct has focused the question on whether intangible digital information is an article as described in Section 337. Several amicus briefs have been filed along with the appellant's brief by parties such as the Electronic Frontier Foundation, Public Knowledge, Internet Association, and Business Software Alliance. These briefs call for the protection of the open internet and raise questions about the enforcement role of private internet service providers if digital data transmitted over the internet can be subject to an ITC exclusion order. The briefs also warn of disruptions to the use of cloud computing, which has become increasingly important in the last few years. And so just as with the ITC proceedings, we can expect submissions from a variety of amici with different positions on the subject. So let me turn now then to the next case that I'd like to discuss this morning, which is the Suprema versus ITC case. In this case, Crossmatch, the patentee, manufactured and sold fingerprint scanners. Suprema, a Korean company, manufactured and imported fingerprint scanning hardware and software. Another party, Mentalix, imported Suprema scanners from Korea and integrated them with its own software in the US. Crossmatch sued Suprema and Mentalix in the ITC for patent infringement, including a method patent that was directed to fingerprint, image capture, and processing. The ITC found that Mentalix directly infringed the method patent by using its own software with the imported Suprema scanners, and found that Suprema induced that infringement. As a result, the ITC issued a limited exclusion order directed to scanning devices imported by or on behalf of Suprema or Mentalix, and also issued a cease and desist order directed to Mentalix in the US only. The Federal Circuit took up the appeal of the case and vacated the ITC's decision, the infringement finding, as well as the cease and desist order and the exclusion orders. Now, Crossmatch on appeal did not dispute that the imported scanners did not directly infringe at the time of importation. There was also no dispute that the imported scanners at issue were capable of multiple non-infringing uses, so contributory infringement was not an issue. In other words, inducement of infringement was the only issue. Now, the Federal Circuit looked at the meaning of the phrase articles that infringe in Section 337 and found that it requires infringement at the time of importation. In particular, the Federal Circuit found that the importation of a non-infringing component of a patented invention cannot be the basis for an ITC exclusion order, even if there is direct infringement in the US by customers and possible inducement by the importer. In the panel decision, there was a dissenting voice, and that was Judge Reyna. In his dissenting opinion, he pointed out that in his belief, the panel's decision overlooks the congressional purpose of Section 337, which is to provide distinct relief at the border to stop infringing articles involved in unfair trade. And it went against long-established ITC practice by the Commission based on induced patent infringement. Following the panel decision of the Federal Circuit granted the ITC's and Crossmatch's petitions for a rehearing en banc, and several amicus briefs have been filed in this case. Interestingly enough, the Federal Circuit invited the Attorney General to present the views of the United States as an amicus in the case. And in the United States' brief, the Attorney General argues, as Judge Reyna did, that the ITC's interpretation of 337 is appropriate in light of the history and purpose of the Tariff Act and is entitled to deference. Several companies have also filed amicus briefs, and these include Dell, Adobe, Ford, Google, HP, LG, Netflix, Samsung, and SAP, Microsoft and Nokia as well. Also, we have several organizations that have filed amicus briefs in the case, the IPO, the AIPLA, and the ITC Trials Lawyers Association. The en banc oral argument is scheduled for February 5th of 2015, and it is expected that the oral argument will focus on the meaning of the phrase articles that infringe in Section 337, as well as the importance and significance of the ITC's long-established practice of finding violations based on induced infringement. So in summary, 2015 promises to be another exciting year at the ITC. The ITC's ruling in ClearCorrect attempted to resolve any ambiguity about the ITC's power to block importation through electronic transmission of digital data, and it has drawn considerable interest from third parties. The stakes, of course, extend beyond patent infringement. For example, the illegal transmission of copyrighted material, included pirated music, movies, or software over the internet, is also subject to the ITC's authority under the clear correct case. Suprema is also an opinion that has far-reaching consequences. There are concerns that the decision effectively limits the ITC's authority to find induced infringement of method claims, because in most cases, such claims are generally infringed only post-importation. That is, the direct infringement occurs only after the act of importation, not at the time of importation. There are also concerns that the Suprema case would allow importers to circumvent Section 337 liability by importing components capable of performing almost all of the steps of a patented method and reserving performance of the last step for the end user in the U.S. And now it remains to be seen whether the Federal Circuit will be persuaded by these concerns, and we will certainly keep our clients apprised of any developments in any of these cases in 2015.
Very good. Thank you, Mircea. These look like some very interesting cases, and we can look forward to these decisions from the Federal Circuit, which look like they'll have some very interesting effects in the ITC going forward. Our next speaker is Kelly Burris, who's going to tell us about some interesting developments at the USPTO.
Thank you, Jim, and hello, everyone. This morning I will be talking about a handful of programs at the Patent Office that can allow you to streamline your patent applications through the USPTO. Let's see. Whoops. They told me how to use this. Okay, so these programs that we'll talk about today are one of many programs that are available at the Patent Office to allow you to gain some efficiencies through the Patent Office. If you're not familiar with these formal pilot programs, I think within the next 10 to 15 minutes, we're going to show you how to save some time, save some money, and get that patent in your hand a little bit faster. So in addition to these pilot programs, there are other programs available. Patent Prosecution Highway, PPH, you've probably heard of that one. The Accelerated Prosecution Program will cost you a little bit more money. That'll help you get through a little bit faster, prioritize your application, and some with little different objectives. But I think all of these programs that we're talking about today really do indicate kind of a renewed sense of cooperation on the part of the Patent Office to help the applicants get their applications through faster. It really is quite a different vibe or tone at the Patent Office these days, where they want to help you. They want to help you get to that amendment that'll get your case through to allowance versus what I can now say, because I'm older, in the old days used to be quite an adversarial relationship with the Patent Office. It really does feel more like they're really on your team and trying to help you get your applications through. And here are 5 programs that can help you. And we'll start going through those. So the first one I wanted to talk about is called the First Action Interview Pilot. And this program's been around for a number of years, and certainly it doesn't prohibit you from interviewing an examiner outside of this program. And actually, if you're not interviewing the examiner, if you're not picking up the phone and calling him or her and talking about your case, you really ought to. You really would be surprised at some of the results that you might see. We've had cases where the examiners actually will call us and say, hey, I have an idea for an amendment that will help you get the case through to allowance. And after you're done scraping yourself off the floor and put yourself back in your chair, you're like, oh, okay, what do you have for me? And which has caused us to, when we talk to the examiner, propose an amendment and then ask them, well, what do you think? What are your ideas on how to get this case through? So it really is quite a different environment there. So I would encourage those of you who do patent prosecution at the USPTO to pick up that phone and to call the examiner, which is not just a phone call. You can also have a video conference with the examiner if you like, right from your computer at your desk. You can go to the different satellite offices and have a nice video conference with the examiner and his or her supervisor. So it really is a great technique to help you gain some efficiencies. So the First Action Interview pilot program began, probably about 4 or 5 years ago, and all utility patent applications qualify for this program. So if it's a continuation, it's a divisional, it's a national phase filing, all those applications will qualify as long as it's a utility application. It doesn't have to be an original, first off the shelf U.S. Utility applications. And this your request for the first action interview has to happen before you receive a first office action on the merits. So, and then that can be filed 1 day before the office action gets mailed to you. So the requirements, the formal requirements of the program are that you have to have 3 or fewer independent claims, no more than 20 claims total in the application, and of course no multiple dependent claims. You have to file your request at least 1 day before the first office action, and it has to be filed electronically through the electronic filing system, or EFS, at the patent office, and be directed to a single invention. So if you have a patent application that has an apparatus claim or set of claims, then a method, you may want to think twice about requesting this formal program. So the way that the process works is you file this request for a first action interview, and you will receive a formal pre-interview communication from the examiner. And this is before a first office action on the merits. In that pre-interview communication, the examiner will tell you, they'll do their search of the prior art, they'll look at your claims and decide whether or not they're patentable. And in that pre-interview communication, they will tell you whether or not the claims are allowable, if they're not, why they're not, the prior art that they're using. Once you receive that communication, you have 30 days to schedule your examiner interview. That interview is not mandatory, although I would highly recommend it. And that 30 days under the new program is now extendable for another 30 days. So really you have 60 days total to schedule your examiner interview and go through what has happened in that pre-interview communication. And I've also included, on this slide, you'll see on the bottom a URL to the Patent Office where you can get more information about the program. Every one of these pilot programs, I'll have a URL where you can go and see more information and frequently asked questions, PowerPoint presentations, a lot more information than what we have here in 10 or 15 minutes. So after you have that examiner interview, you can propose amendments just like you would in a normal examiner interview. The examiner may have amendments for you, and then after the interview, if there's allowable subject matter, you will receive a notice of allowance without any office action whatsoever. If the claims are not allowable, even if you do amend them, you'll receive your first office action and you'll get on track like you normally are in a standard patent application. So that's the general process for this first action interview pilot. We've met this program with a good amount of success, especially if you're in a hurry to get the application through. It does not take your application out of order and prioritize it at all, as some of the other programs will that we'll talk about. So you're still in the queue waiting for your application to hit the examiner's desk, but it is a way to get it through the program a little bit faster. Okay, so the next pilot program that we'll talk about is the After Final Consideration pilot. And this program is great because it allows you to avoid the cost and the time with a request for continued examination, which, as we know, is a pretty hefty fee nowadays. So after you receive a first office action and you respond and you receive a final office action, in the past we file a request for continuing examination, a lot more money, it goes back into the queue, and the examiner will pick it up again. So after final is really in a situation where you're getting really close to allowance with the examiner. Maybe just a few amendments need to be made to get the case through, and you don't want to go through the time and expense of a request for continued examination. You file your after final consideration pilot. And a lot of times we actually when we talk to the examiner in an interview, we'll ask him or her, how do you feel about an after final consideration? Because this program allows the examiners, it gives them a couple of hours to do prior art searching with the amendments that you file, and they'll tell you, well, no, this is really going to require an extensive search, I'll need an RCE, or yes, I think this is ripe for an after final consideration pilot, and they'll give you an indication of which route you should go. This program is available for all original utility plant or design patent applications. Importantly, you have to amend at least one of your independent claims, and it has to be a non-broadening amendment. So if you're just going to present arguments to the examiner, not a program that you want to use, but if it's a slightly narrowing amendment to get the case through to allowance, possibly file a continuation as a follow-up to go after more broad claim coverage, you can do that as well. But you have to amend the claim with this response. You want to be wary of the timing of when you file these. If you're getting close to the 3-month date, or even if you're into your extension periods, the 1, 2, and 3-month extensions, the examiner may get back to you after the next extension period, so you'll have to pay more fees. So just be wary of the timing and when you file this and when the examiner gets back to you. There is a new feature of an examiner interview, which typically happens anyways, but now under the new, the revised rules, after the examiner conducts that search, uses that 2 hours, based on the amendment that you filed, he or she will call you and schedule an interview to go over the results of their supplemental search and whether they're going to allow the case or not. Actually, that happens, the examiner interview happens if they're not going to allow the case, so they kind of give you an idea of why, so you'll know, okay, now what am I going to do? Am I going to file an RCE? Am I going to maybe abandon the application? Hopefully not. File a continuation. But they will call you and let you know what happened from that search and why they're going to continue to reject the application. And this pilot program has been extended through September of 2015, and there's a URL there at the bottom that you can go to. And a lot of these pilot programs, they have an initial expiration date, which has been extended in almost every single one. So I expect that you'll see that September date pushed out because the applicants are having a lot of success with this program. The next pilot program we'll talk about was actually, I was surprised to see when I looked this morning, it's been in existence for almost 10 years now, and this is the pre-appeal brief conference pilot. And this is a program that applies when you're having a really hard time with the examiner. You're just not seeing eye to eye. You think there are some errors in the examiner's analysis of the prior art or their legal arguments, and you want a second set of eyes on your application. You're not, unlike the after final consideration pilot, you're not getting anywhere with the examiner, and you just want somebody else to look at it. So what you can do is you can have a panel of examiners or supervisory examiners review the application with the examiner with your pre-appeal brief request. So what you do in this program, your claims have to be rejected at least twice, and you file your notice of appeal, your standard notice of appeal, and you have to submit your arguments in 5 pages or less that point out why the examiner is wrong. Where are the errors in their analysis of the prior art, of their claim, of the interpretation of your claims. You have to, again, it's important to note that you want to point out their errors, their omissions, that you don't want to get into, well, here's what our claims mean, here's what the prior art teaches, and get into the arguments that you previously presented in your office action responses. So you want to be clear, concise, to the point. I know my litigation friends here are freaking out at 5 pages, but you can still do it in 5 pages. And yes, for those of you who asked that question in school for double spacing and larger size font, you can use single spaced format for your 5 pages as well, so you can get a little bit more in. But it's generally better to keep it, short and to the point, and direct the panel of examiners to what you're trying to focus on. You can't file any claim amendments with your pre-appeal brief conference request, and you have to file again with a notice of appeal on the same day. This program is applicable to reissue applications, but not to reexamination proceedings. And then, as I said, you'll have, typically it's 2 examiners in that same art unit that will look at the request with the examiner. They'll have a conference, they'll review the case, and then you'll receive a decision back within 45 days whether or not you can avoid preparing that long and extensive appeal brief to go to the Patent Trial and Appeal Board. And there are 4 things that can happen out of that review by the board. First of all, they can sustain the examiner's rejection and say, okay, this is going on to appeal, and you'll have to prepare your full appeal brief. They will, secondly, they could agree with you and say, yeah, there are some good arguments here, and we're going to throw this back into prosecution. We're going to re-enter the examination process, and we're going to help the examiner see what it is that you're trying to argue. The third thing is they could basically pass the application to allowance and say, yeah, we fully agree with you, the examiner's wrong, and here's your notice of allowance. which is what you'd really want. Happens sometimes, not very often. Or fourth, you could get a response back that basically says you have a non-compliant request for a number of reasons in those rules that I mentioned. So this is a little more extensive program. It takes a little more time to prepare your request and to make sure that you're focusing on what the examiner did wrong. But there is a way to get a second set of eyes on the application if you and the examiner are not seeing eye to eye. And this is happening less and less these days. Okay, so the fourth program that we'll talk about is the Quick Path IDS. Not too terribly glamorous. The information disclosure statement, as everyone who's in this field knows, anything that's material to the patentability of your claims must be disclosed to the Patent Office. And a lot of times you will receive a notice of allowance, you'll pay your issue fee, and lo and behold, some new prior art comes to your attention from an international search report, a corresponding foreign application, and in the past what you've had to do was file a request for continued examination, pay the fee, go back into prosecution, and then get another supplemental notice of allowance. Well, this, I say eliminates the need for a request for continued examination, although you still have to file what's called a conditional RCE with your request. So you receive you pay your issue fee, you receive the prior art, you can file a Quick Path IDS with a conditional RCE. If the examiner deems that the prior art has no bearing on the allowance of the claims, then you will not be charged that fee and it will pass to issue. If the examiner deems that the prior art is worthy of a second look and it does have an impact on your claims, you will re-enter examination and the RCE will be filed. And then you have to file that request via the electronic filing system again, and it is limited to original utility applications only. So no continuations, no divisionals, no national phase filing, so it has to be an original U.S. patent application. And then the last program that I wanted to talk about was the glossary pilot program. Fairly new, it was just announced in March of last year. It was only supposed to go through the end of 2015, and they've extended it now to June, to June 2nd of this year, which may last longer because it's receiving some positive feedback. This program is limited only to claims and software-related patent applications. There are specific U.S. classifications that's limited to. There are 2100, 2400, 2600, and 3600 for those of you who are familiar with those classes. It's in those programs only. And what you do in the glossary pilot program is you include a definition in your specification of each claim term, not every single one, but the ones you think need a definition. You would put a glossary in your patent application that says this is what real-time streaming means, and you would define that in a glossary. And again, it's limited to those specific classifications. And the reason why you'd want to do this is because if you file your glossary pilot request, your application will be expedited. It will go to the top of the examiner's pile. So there's an incentive right there to at least include some terms in a glossary so that it receives expedited processing and it gets on what's called the examiner's special docket. And so that's, and again, I have a link at the bottom of the page there that you can go to learn more information about these programs. And again, if you have a decent volume of applications at the Patent Office and it's taking some time to get them through, and you want to get them wrapped up, or you've got some pressure from high above to get your costs down, these are programs that you want to take advantage of. And that's all I have. And so now I will pass it back to Jim.
Thank you, Kelly.
Oh, I'm sorry. One more thing. There are some statistics I had at the end because I'm an engineer and I have to show statistics, but here's what happened after they announced the program in March and it went through December. You see there that they've gotten a pretty good response on the program. So there are some statistics there. Sorry.
Thanks, Kelly. It's refreshing to hear and see that there is a department within the government that actually is trying to help us and provide more cost-effective and efficient solutions. So very interesting developments. And before I introduce our final speaker, I just want to remind all our attendees today that we do welcome your questions. There is an opportunity or facility that should be available in a chat box where you can send us a question live, and to the extent time's available after Scott's presentation, we'll answer as many questions as we can. Which brings me to Scott Slavic. Scott's our final speaker today, and he's going to talk about some important developments in the trademark and copyright areas.
Thanks, Jim. 2014 was an incredibly active year at the Supreme Court for copyright and trademark cases. Today I want to discuss two of the most important ones. The first is the Aereo case, and the second is the B&B hardware case. The first case that I'm going to discuss is the Aereo case. And before we get into the legal merits of the case, I wanted to explain the facts behind it because they play a large role in the case's outcome. Aereo's process is an interesting one. It's pretty simple and it's very, very lucrative. Step one is outlined here. A subscriber subscribes to Aereo's service. The subscriber wants to watch a television show that's currently being broadcast by a television network. Well, the subscriber goes to Aereo's website and selects the television show that the subscriber wants to watch from Aereo's list of shows. This is the first act that's committed by the subscriber. So far, Aereo is just passively sitting there not doing anything. Its subscribers are selecting the shows to watch. This sounds simple enough. Okay, so step two is Aereo's step. Once the subscriber picks a show, Aereo then assigns one of its tiny little antennas to that subscriber and to no one else for the duration of the program. Aereo then turns its antenna that's assigned to that individual subscriber, and it finds the television program out in the air and pulls it down. So Aereo's antennas, just to explain, they're really, really small. You can fit millions of them in a very tiny space. They aren't like the antennas that we're used to on our houses. They're about dime-sized antennas. Step three. Aereo's servers then save the television program to a subscriber-specific folder on Aereo's hard drive that is assigned to that specific subscriber. This is the subscriber's personal copy, according to Aereo. This is not transmitted to anyone else, but only the subscriber, and the saving of the program takes a few seconds. Step four. A few seconds after it's downloaded by Aereo into the subscriber's personal file, the personal copy is then streamed to the subscriber on any of the subscriber's wireless devices, their phones, their iPad, their computer. Well, who would be mad about this? Certainly not Aereo, not the subscriber. The subscriber loves it because Aereo's services cost less than the subscriber's cable bill. But now wait a minute. How happy are CBS, ABC, NBC? The broadcast networks are still paying a lot of money to produce these television programs, but Aereo isn't paying the networks like the cable companies do. It's just pulling the signals out of the air. So CBS, they're kind of mad about this. CBS, ABC, and a bunch of other networks all sue Aereo. It's hard to find something that ABC and CBS are going to agree on, but hating Aereo's business model is apparently one of them. So the broadcast networks all sue Aereo, alleging copyright infringement of their television programs based on the argument that the Copyright Act gives the copyright owners, in this case CBS, ABC, a bundle of rights, including the exclusive right to perform a copyrighted work publicly. Well, the transmit clause of the Copyright Act adds a little flesh to what it means to perform a copyrighted work publicly. It explains that the exclusive right to perform a copyright includes the right to transmit that copyrighted work to the public by means of any device or process, regardless of where the members of the public are located or when they receive it. So what happened when they got to court? Well, the district court denied CBS's motion for a preliminary injunction, and the Second Circuit affirmed the district court's holding that what Aereo was doing was not a transmission to the public. Instead, what Aereo was doing was sending a private transmission that was available only to a specific subscriber. Aereo wins. But wait a minute. Did you think that CBS or ABC were just going to give up? Not by a long shot. They have a lot of money tied up in broadcasting and didn't feel like turning over their product for free. So they appealed to the Supreme Court, and the Supreme Court granted cert. Well, the question presented was whether Aereo infringes the network's exclusive performance right by selling Aereo's subscribers a technologically complex service that allows the subscribers to watch television programs over the internet at about the same time as the programs are broadcast over the air. Now, if you can't tell by the way the question presented looks, the Supreme Court was not really liking what Aereo was doing, and it was about to get a lot worse for Aereo. In analyzing the question presented, the Supreme Court broke the question into two parts. One, does Aereo perform? And two, if so, does Aereo perform publicly? As for whether Aereo performs, Aereo argued that it didn't. It claimed it was just a supplier of equipment. Its equipment operates as a home antenna would or as a DVR would. It claimed it wasn't performing anything. Well, the Supreme Court said, okay, let's look back at our past precedent here. We dealt with something that is similar to what Aereo is doing before. In the late 1960s and early 1970s, the Supreme Court dealt with two cable television cases in Fortnightly and Teleprompter. The Supreme Court ruled that network broadcast signals could be legally carried to home viewers by the cable companies without incurring copyright liability. In other words, the cable companies did not have to pay the networks to transmit their shows to subscribers. Well, that obviously didn't sit well with the networks. So the networks went to Congress, and in 1976, Congress listened and amended the Copyright Act to specifically overrule Fortnightly and Teleprompter, and enacted the Transmit Clause that we talked about before, that says an entity performs a copyright work publicly and therefore is liable for copyright infringement when it transmits a performance to the public. And this clause covered cable TV systems. Well, the Supreme Court in Aereo then said, under the amended Copyright Act, Aereo's activities are similar to those of the cable TV companies in Fortnightly and Teleprompter, and as such, we conclude that Aereo is not just an equipment supplier, but that it's performing copyrighted programs and it's violating the law. Okay, so the Supreme Court found against Aereo in the first question, but what about the second one? Is Aereo really performing publicly? Aereo says, fine, maybe we're performing the network's programming, but we're not performing it publicly, so we should still be okay, right? Aereo explained, each of its antennas is dedicated to a single subscriber. Aereo makes a personal copy of the show. Aereo then transmits the copy to that one subscriber. Only one subscriber can see and hear the show. How can you call that public? Here's where the Supreme Court's reasoning may have gotten a little loose. It says, nope, you're the same as the cable companies. You're giving your viewers the same viewing experience as cable, and you're serving the same commercial objective. In other words, we're not going to be distracted by the technology that you're doing, and neither are the viewers. People want to watch a show, and they don't care how they get it. They don't care if you're showing their show to a bunch of people or to only them. They just want to watch it. In other words, the Supreme Court doesn't want to get caught up in the technicalities of what Aereo is actually doing. They just want to look at the outcome. The court said, in essence, transmitting the same show to many people is transmitting it to the public, regardless of how many separate communications you're making. You can think of it this way. You could make 100 different phone calls on behalf of a political candidate to 100 different people, or you could give one speech to 100 people. You're still getting the same results. In other words, the majority of the Supreme Court felt that Aereo's system is really similar to cable TV, that in the same actions that Congress tried to stop in 1976. And the Supreme Court didn't want to allow those same activities now. And any differences between Aereo and the cable companies, didn't concern the nature of the services that Aereo is providing, but instead were just technological differences. The end results are the same, and the court didn't want to get sidetracked by Aereo's technical process. If Aereo had won, it would have completely remade the network broadcast business model. So instead, we all still have to pay for cable, and no tiny antenna is going to cut those bills for us. The second case that I want to discuss is the B&B Hardware versus Hargis case. Now here, the background facts are a little bit more straightforward. B&B obtained federal trademark registration for its seal-tight trademark for use in connection with fasteners. Hargis later applied for an application for seal-tight, spelled slightly differently, but also for fasteners. Hargis's application was approved by the PTO and published for opposition. B&B opposed Hargis's application. The Trademark Trial and Appeal Board found that the parties' marks were confusingly similar and rejected Hargis's application. Hargis said, okay, that's fine, we won't have a federal trademark registration, but we've been using this mark all along and we're going to keep doing so. Well, B&B then sued Hargis for trademark infringement in a district court. Well, the district court's jury found, unlike the TTAB, that confusion between the parties' marks wasn't likely, after the district court refused to give preclusive effect to the TTAB's prior decision that confusion between the parties' marks was likely. The Eighth Circuit affirmed the jury's finding and held no confusion. Well, B&B wasn't ready to give up yet. It appealed to the Supreme Court, and it argued because there is a major split in the circuit courts as to what effect, if any, an opposition finding should have on a subsequent district court litigation, the Supreme Court should take the case. See, the Third, Seventh, and Federal Circuits give the TTAB's finding collateral estoppel effect. The Second Circuit will give the TTAB's finding collateral estoppel effect if the TTAB considered the marketplace context of the competing marks during its analysis. The Fourth, Fifth, and 11th Circuits give the TTAB's finding no collateral estoppel effect, but they do give some deference to it. The Eighth Circuit, as we saw in this case, gives no collateral estoppel effect or deference to the TTAB's decision. Now, interestingly, the Supreme Court decided to grant cert. The Supreme Court decided that it was going to look at two different issues. First, it's going to examine whether the TTAB's finding of a likelihood of confusion precludes the losing party from relitigating that issue in a subsequent infringement litigation, in which likelihood of confusion is an element. And second, the Supreme Court is going to look at whether, if issue preclusion does not apply, the district court should be required to defer to the TTAB's finding of a likelihood of confusion absent strong rebuttal evidence. Now, it's important to understand the difference between an opposition and a district court lawsuit when considering the potential impact of the Supreme Court's decision in this case. First, oppositions are determined by the Trademark Trial and Appeal Board, an administrative agency, whereas district court actions are decided by Article III judges. The legal analysis between the actions is different. The TTAB focuses its inquiry on the marks at issue and the goods covered by the asserted registration and the opposed application. In a district court action, the court focuses much more on the realities of the marketplace. It looks at trade channels, the sophistication of the party's customers, and things like that. Now, the legal basis for the decisions are different as well. And perhaps most importantly, the relief is different in that the TTAB only deals with whether or not an applicant is allowed to get a registration for its mark. The TTAB cannot enjoin the use of a trademark. The TTAB can't award damages. A district court, in contrast, can do all of those things. So it's really important to see how much different it is between an opposition and a district court action. And finally, the burdens of proof are different between the two as well. Well, why does this case matter? Well, if collateral estoppel applies to TTAB decisions, it could change how applicants respond to oppositions. Because the relief that a successful opposer can receive is limited to only blocking the applicant's application, oftentimes applicants will give up an opposition rather than spend the time and money involved to fight it. And they'll risk the fact that the opposer will actually go on to sue them in a district court action to try to stop their use or obtain damages. If, however, the Supreme Court gives preclusive effect to the TTAB's finding of infringement, even in the cases of defaulted oppositions, well, it could cause applicants to have to fight out oppositions, which could in turn cause applicants to not file trademark applications in the first place, because oppositions and district court actions can often cost about the same. District court actions may cost a little bit more, but oppositions can be very expensive. Well, this could have obviously a major impact on current trademark practice depending on how the Supreme Court rules. Now, the decision is expected sometime in April or May of this year, and as soon as it comes out, we'll send around a client alert and update all of our clients and offer suggestions on how best to deal with this case in its aftermath.
Thank you, Scott. Sounds like some very interesting cases coming out of the Supreme Court. We do have time for a few questions. Kelly, the first question is for you. It's really a multi-part question, but there were two of these USPTO procedures that currently have sunset dates, right? The after final consideration program, I think, was in September of this year. It's set to expire, and the glossary program is set to expire in June. And so you indicated that you thought they're likely to be extended, but some of the people in the audience are wondering, well, when can we expect that to happen? And because there's some uncertainty, is there some action maybe we should be taking now before these deadlines in case the programs are not extended?
Yeah, that's an excellent question, because a lot of times we don't hear about the extension of the program until the week that it expires or just a few days beforehand. If it's a program that you're interested in, and I should have mentioned this earlier, the Patent Office is really much better nowadays at soliciting input from the patent applicants. What do you think of this program? They have roundtables, they have focus groups. So if it is a program that you find is very beneficial, there are means through the Patent Office where you can go in and you can provide your comments on whether or not this program worked for you. And you can also recommend possible changes or adjustments to the program. And if there is enough input, they typically continue the programs at a minimum. And if enough applicants say, within that 30-day window, it'd be nice if I could get one extension. If enough applicants are saying that, they will then go ahead and change the rules, which is what we've seen over the years with almost all of these pilot programs. And one of them is 10 years old, so it probably should not be called a pilot program, but it's a way to keep it open. So if you're interested in keeping the program going, go to the Patent Office, provide your feedback. You can do it in the form of email or a formal memo and send it in, and pick up the phone and call the supervisors and the managers at the Patent Office, and they will. You'll be surprised. They'll be very helpful.
Okay, great. Thank you. Now, if people have more questions, we're getting low on time today. I want to wrap up with a few observations, reflections. But if anyone in our audience has questions you want to direct to any one of our panelists, please feel free to email any of us directly. You should have our contact information, or you can always go to our website at www.brinksgilson.com. You can find all our bios there and contact information. So as I was listening to our presenters today and the things they were saying, I jotted down a few notes and just some overall reactions and reflections I wanted to share with you today. So with respect to these cases that Mircea discussed involving the ITCs, the reach of the ITC's exclusion orders, so I thought about these are really important in terms of the larger picture of enforcing IP rights. Those of us who spend a lot of time in IP litigation are aware that it's become very difficult to get any type of injunctive relief in the district courts. And even it's becoming more and more difficult to get large damage awards. The courts are requiring more stringent standards applied to damage experts in particular. We're seeing more Daubert decisions. So if injunctive relief is really important to you for a competitive advantage, the ITC is the one form that really provides probably your best opportunity for injunctive relief. So these decisions that are going to affect the scope of those exclusions orders are very important and something that you'll want to pay attention to. And then with respect to Kelly's comments on the USPTO, as I mentioned, it's refreshing to hear that the Patent Office is being so willing to really engage and interact with patent applicants to try to reach a cost-effective and efficient result. And I think these 5 avenues are important for another reason. Patent rights, the life of a patent is 20 years from the date of filing. And it's a real advantage to get the patent issued sooner rather than later. While there's still an opportunity to get damages during the time an application is pending, it's difficult for a number of reasons. It's always better to have your patent in hand. So to the extent you can take advantage of one of these pilot programs to get your patent actually issued sooner and for less money, that's always good. These are really good programs. And then I was listening to Scott talk about the Aereo decision and the upcoming decision and the B&B case. It reminded me that the Supreme Court rendered decisions in a number of other cases last year affecting both patents and standing under the Lanham Act. There are more decisions we expect from the Supreme Court this year in the IP field. And of course, that's the highest court in the land, and what they say has a significant effect that all courts have to follow. On the other hand, one of the things we've observed with the Supreme Court is they tend to address issue on a policy level and discuss issues with a broad brush. It reminded me of a discussion I had with one of our late partners, Bob Harmon. Bob was a real legal scholar, author of Patents in the Federal Circuit, Patents of the Supreme Court, 2 treatises that are still widely used today. And I remember I had the opportunity to talk with Bob once casually about the Supreme Court at a time when they weren't taking many cases. And he said, Jim, it's interesting because the Supreme Court, as he said, treats these issues with a broad brush, but there's always a lot of unresolved issues and details they don't attend to and unintended consequences. And it often takes the district courts and the courts of appeals like the Federal Circuit another 10 years to really work through those details and unintended consequences till we really have some certainty in the area of law that the Supreme Court addressed. So for all those reasons, it's very important that we not only read the Supreme Court cases, but try to think about, okay, what are the unintended consequences and how can we best deal with them for our clients to put them in the best position to procure, enforce, and defend their IP rights. So, we're out of time today. I really want to thank everybody for listening in and attending our V panel today. Especially, we'll give a shout out to our friends across the Atlantic Ocean who are joining us today. It's great to have your participation. Thank you, everybody.